Welcome back, everyone. Hope you had an insightful session in the first part, and I think there was a lot which was beyond consent, and that's something that at least came out as one of the messages in the first one. So we will strictly now move into that and examine consent in the context of its alternatives. And in this very interesting panel, I'm pleased to welcome our panelists. And before that, my co-moderator, Dr. Gabriela Zenfeld-Fortuna. She's the Vice President for Global Privacy at the Future of Privacy Forum, and she's an expert on privacy developments and counsels on the EU data protection law and policy. So great to be having this session with you, Gabriela. And for our panelists, let me just quickly introduce Francis Zhang. Is the Deputy Director at the Data Policy at PDPC Singapore. He's also the member of the Singapore Legal Service and experienced in data protection laws and regulations for both public and private sectors. So Francis, you surely know, but there's a lot of inspiration that has been taken from the Singaporean experience in our journey of thinking through this law. So your insights, I would feel, therefore, are supremely relevant. And welcome, Leandro Eguri. Again, Leandro is a Deputy Commissioner of the National Privacy Commission at Philippines. He's a lawyer, law professor, and privacy advocate. Very glad to have you here. And Kazimierz, I'll use your first name, and welcome here. You are a member of the Cabinet of the European Data Protection Supervisor, where you are looking at the work of the EDPS in the field of supervision, policies in the field of justice and home affairs. Something that we really look forward to on your views. So just in terms of industry discussion that we have had initially, I think there is a sense that it's easier, or let's say there's a limitation of the grounds beyond consent vis-a-vis what we generally see in the laws in the Indian context. So that is something I think becomes a lens for us to examine this. And what I will do is that quickly, Varun, can you put up a screen where you can just refresh us on what are these alternatives, and so that we can be all on the same page that is it so limited, and what could be the scope of that, and talk us through, Varun.
Sure. Thanks, Ashish. And thank you, everyone, for joining us for this panel. It's been a great experience to co-host this with the Future of Privacy Forum. I think what emerged from the first panel actually was equally important to figuring out how we actually get consent in a valid way is also about figuring out when consent isn't the best way forward and when we would want to rely on one of the alternatives. And I think that the alternatives to consent in the Act are located in two different places, which is the specific places that I want to point to in the Act, and what actually emerges as alternatives is what I just want to quickly cover. I think everybody's familiar with the fact that in Section 7, we have certain legitimate uses which are the alternatives to consent. And I think while many of them do map to international equivalents, for example, we've got slightly more specific versions of the vital interest and public interest grounds. We've got slightly more specific versions of the legal obligation grounds as well. We've got one specifically for the purposes of employment that's been a great topic of discussion in the chat. And of course, there are some for the state as well to perform their state functions and to provide subsidies to data principals. But the really interesting one that I think that's occupying everybody's mind in India right now is the one under 7A, and I've kind of reorganized them so that 7A is front and center, that it states, and I'm just going to read out what the Act says, that it's processing for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary. Data principal is our version of the data subject. Data fiduciary is our version of the data controller. And crucially, in respect to which she has not indicated to the data fiduciary that she does not consent to the use of her personal data. So we've got a bit of double negatives going on there, but it's a pretty interesting version of implied consent. And I'm feeling comfortable calling it implied consent because elsewhere in the Act, we actually see the reference to this section as a form of consent. So if you look at Section 11, which talks about the right to access, that mentions that the right to access is available when the ground for processing is consent under 6, but also consent under 7A. And so I think that it's fair for us to say that this is also a form of consent. But it's important to realize that consent also isn't required if you're relying on some of the exemptions that are present in Section 17 of the Act. And there are two categories. Section 17(1) is where much of the Act doesn't apply, but certain obligations do continue. So for example, if you're a data fiduciary relying on some of the grounds in Section 17(1), you still have to ensure security safeguards and you have to be accountable for processing carried on by your data processor as well, generally. And of course, complaints can still be made to the board. The interesting thing from an industry perspective here is that we've got 3 or 4 of them that are relevant to in Indian industry in particular. So you've got enforcing legal rights. You've got one specifically for debt recovery, but sectoral law continues to be relevant here. You've also got one for mergers and acquisitions and generally corporate actions of that nature. And you've got one for processing of foreign personal data in India, which has been in our law since the early days of the draft. We've also got one for courts, and we've got one for preventing and detecting offenses as well. But we've also got in 17(2) a slightly differently worded set of exemptions. Here, the Act doesn't apply if you're relying on these 2 exemptions, but it depends upon delegated legislation. So the key one for industry here is that you've got research, archiving, and statistical purposes. So where processing is necessary for these purposes. 2 crucial riders. If the personal data is not to be used to take any decisions specific to a data principle, and such processing is carried on in accordance with such standards as may be prescribed, which means that standards that will come out in delegated legislation and rules. So while the Act doesn't apply, those standards will continue to apply, and you can't use the personal data for taking a decision. And then we've got the other exemption for state agencies, notified security agencies as well. So they have to be mentioned in the specific notification for that exemption to continue to apply. So I think from an industry perspective, it's good to look at 7, and everybody's talking about 7A, but it's also good to look beyond 7 and look at 17. And with that, Ashish, over back to you and Gabriela for our panel discussion.
Thanks, Varun. So let's quickly get into the discussion. And Gabrielle, may I leave the floor to you to get this interesting conversation going? Over to you.
Yes, thank you so much, Ashish, and thank you, Varun, for that very useful overview of how the Indian Data Protection Act actually envisages the architecture of the lawful grounds for processing, as we call them in general data protection law. And thank you to our distinguished panelists, and particularly to Leandro and to Francis, because it's quite late both in Philippines and in Singapore right now. So we're very grateful for your time helping the public policy conversation in India, which is so important right now. Kajik, I will first go to you because the GDPR and the previous EU data protection directive have been around for a very long time, and the concept of lawful ground for processing is quite important. But what I want to ask you is, how important is this concept of lawful grounds for processing in data protection law? Why do we care about consent and the other lawful grounds? What's the role of this concept in the bigger architecture of data protection law? And then also, if you can map the lawful grounds in the GDPR for those who may not be very familiar with them right now in India among our audience. And perhaps an example of what type of processing operations can fall under the lawful grounds in the GDPR.
And it's all in 5 minutes, right?
It has to be.
I'll give it a shot. Thank you, Gabi. Thanks, Ashish. Thanks everybody for having me. It's really a pleasure, even if it meant me having to dive into the endless richness of the newly adopted law very quickly. But you never say no to Gabriela, so I had no choice. I want to start by a few disclaimers. First, whatever I say as the representative of the European Data Protection Supervisor does not constitute an official EU position on the law in India. Please be mindful of that. I guess also as an introduction, I would just like to very much say that I very much appreciate the fact that the concepts in the newly adopted law are not identical to the GDPR. I mean, on one hand, of course, in the EU we say how GDPR is the golden standard, and we deeply believe when we say it. We really mean it. But at the same time, we understand that it's often pointless to just copy paste laws into other legal cultures. We have the same issues in the EU, and we need to apply directives, implement directives, and what matters is the actual objective behind the law, which is the protection of fundamental right, the very essence of it. And I'm using the word essence because what actually happened yesterday in Brussels was a very cool seminar we organized on the essence of the right to data protection. And the word essence kind of resonated with me onto the meeting today we have, because the essence is very kind of closely linked to the concept of essential equivalence of protection. So the notion that we use when we in the EU think of other laws, which is the case here in the case of the law in India. But the essence is also something that was yesterday discussed in the context of lawfulness, or in the context of legal basis for processing. And of course, that brings us to consent as something that is at its very core. And there was a discussion yesterday, whether other grounds for processing are an exception to the rule that the consent is there. Are there equal? There was a phrase that yesterday was mentioned several times. Some rights, every right is equal, but some rights are more equal than others. And we're going to kind of extrapolate that phrase into the discussion about lawfulness. To answer your question, Gabi, I think lawfulness is crucial if we look at data protection law from, let's say, more formal or functional perspective. Data protection is a law that tells you when is it that you can process data. When you have legal basis for it. Without that, there is no data protection law. Without that, we don't even need to go to other tools that data protection law gives us, because it's illegal at first place. There was a very interesting conversation that I joined, a little bit halfway before, and I saw how it's all about. At a certain moment, it was all about consent and how we can misunderstood it and how we can maybe overuse it somehow. Sometimes Eduardo was mentioning how it's impossible in the business reality. I would say maybe it's impossible in a reality as such. Maybe it's less about the business; it's more about whether you can realistically expect from people to give consent to literally everything and have it at the same time, very concise and simple and short and sweet. But what I would like to say is that from the EDPS perspective in particular, as a supervisory authority of only public administration which normally processes data on the basis of other grounds than consent, of course, the alternatives are, at least some of them, equally valid. To my understanding, and forgive me, I'm not an expert in the Indian law, but to my understanding, also thanks to very informative slide that we've seen, the state law can also introduce legal ground for processing. I cannot stress enough how important it is that such grounds cannot be seen in isolation from the principles of data protection, namely from Article 7 and 8 of Charter in the context of the EU, but also similar context abroad. What I'm trying to say is that if the legislator allows for legal ground to be based on the law, it means it kind of represents a democratic will. It represents somehow a will of that person, that person who will normally ask for consent. So it's still an emanation of the will of an individual, which should represent the principles of proportionality and necessity. To be honest, when I was preparing for the meeting today, I was wondering to what extent the voluntary sharing is voluntary and to what extent it's implied. In the context of GDPR, when we discuss consent, we often wonder what does freely given consent mean. or informed consent. And I am very curious to see how in next months and years this will develop in India. If it's a voluntary sharing, if it's indeed I'm consciously saying, I also want you to use this data for whatever else you want, that's more close to consent GDPR like. If it's implied, then semantically it's kind of going against the notion of freely given consent. So I'm very curious, and maybe you guys can also share your views on that, how that's going to work in practice. That brings me. So we had and I know I need to finish soon. I mentioned the consent as one type of basis, and here GDPR also gives contract or exercise of a contract as one of these. I would put them together as processing as a result of a will expressed by an individual, processing as a result of law, whether it's exercise of public interest or public authority. And then last one that was kind of mentioned, I think, before, and this like the key question also currently in Europe, the legitimate interest. And I have very pleasant role of not being able to say too much on that, given the role of the ADPS in the ADPB. But you guys are very well aware of the recent Meta judgment and the discussion, for example, on whether legitimate interest could have been used by Meta in the context of behavioral advertising. It seems not. My point here is that that's something that 5 years into application of the GDPR is posing a lot of questions to the ADPB and to the court, questions that are admittedly controversial and touch upon the business models and economic implications. So you see there is law, it's been there for 5 years and we're still asking questions. What does it mean for India? I think it means that a lot will depend on the practice, a practice of authorities, whether it's data protection authority, which I understand has limited powers to issue guidance, but there's stronger role for central government to do so. So this one thing, and then kind of good luck with the coherence when it comes to the court's positions on this. India has it's a one country compared to EU, which is 27 plus few more from European Economic Area. But the challenge remains, I think, equally grave. How to ensure coherent application, and I'm happy to discuss later on how we can do it more practically.
Thank you so much, Kajik, and I think you laid out quite nicely how important this concept of the lawful ground for processing is, because that's technically the first type of assessment that a data protection authority does when it looks at a particular legality or lawfulness of a processing operation. Is there a valid lawful ground in place? So this is the point where such analysis starts. And then, of course, legal regimes have dealt differently a bit with what they consider to be a lawful ground. And this is a very nice segue towards Francis. Singapore was on a very interesting journey in the past 5 years or so, because the Personal Data Protection Act was very, very consent-centric. But then a reform of the act happened 2 or 3 years ago, if I remember correctly, where some of the key modifications were that the lawful grounds for processing expanded a bit. And there were a couple of exceptions that were included. So I would like to ask you, what put Singapore on this journey to go from a very consent-centric legal act towards allowing for some other lawful grounds for processing? What were the challenges that were happening in the past? And maybe there are lessons learned that you can share with us from that.
Thank you, Gabriela. So maybe just to point out that the Singapore Personal Data Protection Act, or PDPA, we take a balanced approach. We always try to balance the interests of the individual and the interests of the organization. And this is actually reflected in our approach towards consent. So we say that you have to obtain consent before you collect, use, or disclose personal data. But there are also exceptions where you can, in fact, collect, use, or disclose without obtaining consent. And I will show a diagram later on, and it will be maybe easier for those familiar with GDPR, the legal basis for processing personal data, it'll be easier to see the mapping. But before I move on to that, this balanced approach that we take is also reflected in the amendments 3 years ago. So for example, on the consumer end, we actually increased the financial penalties threshold against organizations, and we introduced a data breach notification obligation. So that is to safeguard consumers' interests. But to help businesses, we also expanded the consent regime. So what we did, we came up with new exceptions. For example, the business improvement exception and the legitimate interest exception, which I will talk a bit more later on. And we also introduced new concepts of deemed consent, such as the deemed consent by contractual necessity and the deemed consent by notification. And now let me put a link into the chat so that everyone can. This is an internet link, but then I would also share the screen for this. Okay, so this is something that PDPC came up with to show how our consent regime is mapped to the GDPR 6 legal basis for processing of personal data. So under the GDPR, as you know, there are 6 grounds: compliance with legal obligations, consent, contract, vital interest, public interest, and legitimate interest. I think some people call it the 3 C's and the 3 I's. It's quite much easier to remember. So for the PDPA, our consent obligation and the exceptions actually broadly map to these 6 legal bases under the GDPR. And as you can see, the 6 different colors can match to each other broadly. So it may not be exactly the same approach, but broadly speaking, that the rationale behind the exceptions actually map to this non-consent legal basis for processing personal data under the GDPR. So maybe let me just talk about the legitimate interest exception. We have a general legitimate interest exception under the PDPA, which is meant to be flexible. And how we balance the interests of the consumer and the organization is that, yes, the organization can rely on such an exception, but there are criteria to fulfill before they can do so. So for example, they have to conduct an assessment to weigh the legitimate interest against the adverse effect on the individual. They have to do this assessment and record it. So if they have not done this assessment, they will not be able to rely on a legitimate interest exception. And they also have to disclose the reliance on this exception to the individuals that they interact with. So it could be, for example, on the privacy policy on their website, or via a signage or notice to them. So this is just one example of how this balance between individual rights and organizations' interest to use data in a legitimate way, this balance can be reflected in our consent regime, even in the exceptions. And also, okay, if you see on the left-hand side in the green box under consent, we also have, besides express consent, we have the deemed consent by conduct, which I think is one of the things that was brought up earlier in the Indian DPDPA. I might talk about that a bit more later on. And we also have deemed consent by contractual necessity and deemed consent by notification. So these are actually considered consent, not an exception to the consent obligation, but real consent. It's just that in certain situations, it may not be so obvious that the individual has given consent, but because of the circumstances, either by conduct or the fact that the contract was entered into between the individual and the organization, or the organization actually has taken some steps to notify the individual, we can then say that the individual is deemed to have consented. Yeah, so that's my section. That's all I have to say at the moment. I'll pass on back to Gabriela. Thank you.
Thank you so much, Francis. And we do see that indeed what the reform of the PDPA brought was another set of grounds that allowed for certain pricing operations to happen without consent. As you were mentioning, we saw the box with legitimate interests, and then we saw some purposes there, like pricing for research purposes. I'm not sure if that was in the previous version of the law, or business asset transactions and so forth. So that was quite interesting to see. Going to Leandro now. Leandro, can you share from the experience in the Philippines, how does the architecture of the lawful grounds for processing look like under the law in the Philippines? And what's your experience with working with those lawful grounds? Can you bring an example of a case where processing of personal data was deemed lawful without consent based on some of the other lawful grounds?
Thank you, Gabriela. Thank you for the invitation to participate in this panel. The way the legal regime in the Philippines is structured is we have various lawful grounds for processing, separate grounds for personal information and separate grounds for sensitive personal information, but they're treated equally. It's not consent first and exceptions to consent. So we have consent, we have processing based on contract, processing based on compliance with the legal obligation. So more or less similar to what you'd have in the EU. We have legitimate interest, vital interest of the data subject, so more or less. Maybe about 1:1 similarity between what you have in the EU and what's in the Philippines. But what we saw here is that consent is still the most used lawful criteria for processing. And I think it's being done that way because there's this impression that it's the easiest one to rely on. It's more convenient, unless they're sure of how to go about using legitimate interest. They'll rely on consent because there's something tangible that they can hold on to. But what that results in is a lot of consent fatigue on the part of the data subjects, where organizations, for the most part, overuse consent and pass the burden to the data subjects to validate and legitimize whatever processing activity that they do. So we've tried to remedy this by issuing we're about to issue a guidelines on consent that sort of tries to fix a lot of the issues that we've seen. We're shifting the idea of blanket consents to just-in-time and layered notices, which will hopefully force the companies to rely on other lawful criteria to process, such as legitimate interest. Speaking of legitimate interest, we're also in the process, hopefully by the end of the month, to issue additional guidelines on legitimate interest to make it more clear for companies so that they can rely on it better. We're also trying to fix problems with deceptive design patterns, because some of the ways in which companies try to get consent from data subjects can be considered manipulative, deceiving the data subject to give more information that is actually required within a specific instance. So we're trying to fix a lot of those things through various issuances and decisions of the Commission. As to instances when we've validated aspects of processing that is not based on consent, in one specific case, we categorically said that the conduct of an audit investigation, even without the consent and actually over the objection of the data subject, is a valid form of processing following the legitimate interest of that specific organization. There was also an instance when we validated the use of legitimate interest as the basis for processing in taking proof of delivery using courier services. So we're in the process of trying to nudge controllers away from using consent and moving more towards legitimate interests and other bases for processing, hopefully to ease this consent fatigue that is currently being experienced by a lot of the data subjects here.
Thank you so much for sharing insights from the Philippines. And I think you highlight how important the role of the regulator is when implementing these requirements in practice. and trying to intervene with guidelines, with let's say motivation and explanations towards controllers that they can rely on other lawful grounds for processing in specific lawful ways, especially when the population experiences consent fatigue. And frankly, in our study that we did across Asia Pacific last year, our APAC office has this series of 14 jurisdictional reports looking at countries in Asia Pacific and their lawful grounds for processing. That was one of our main conclusions, that a lot of the legal regimes over-rely on consent to the point where consent fatigue is experienced, and consent is very, very rarely meaningful when obtained. So such interventions with guidelines over time are something that's very important. I will go back to Francis and then just bring Ashish into the conversation. But Francis, let's pick up that point on what was it? Not deemed consent. It was deemed consent by conduct. Yes, deemed consent by conduct, because our understanding is that this voluntary provision of personal data ground in the DPDPA was perhaps inspired by this lawful ground in the Personal Data Protection Act of Singapore. Can you talk a bit about your experience as the regulator enforcing or working with that lawful ground for processing, and if there are any lessons learned from that perspective?
Okay, thank you, Gabriela. So actually, I didn't know that the Indian DPDPA took reference from the Singapore law, but after looking at the provision, I can see why there is a similarity. So maybe it's easier for me to explain if I refer to the Singapore's version. I just inserted a internet link inside, and that leads to the exact provision in the Singapore PDPA that talks about deemed consent. So it is section 15.1, and as you can, maybe I will just read it out. An individual is deemed to consent to the collection, use, or disclosure of personal data about the individual by an organization for a purpose if, and these are 15.1a and 15.1b are conjunctive. You have to satisfy both of them. The individual, without actually giving consent, mentioned in section 14, which is the express consent, voluntarily provides the personal data to the organization for that purpose. And also equally important, it is reasonable that the individual would voluntarily provide the data. So again, this is an example where we try to balance the interest. So while we give the business, the organization, a way to deem consent, but they have to make sure that the purpose is reasonable. And that's 15.1b. So what do we mean by voluntarily provide? And I think a few points that can be how we interpret this provision. First, when we say voluntarily provide, that means the action comes from the individual. The individual must have taken some steps to allow his or her personal data to be collected without actually giving consent. So there may not be evidence that the individual has given consent, has said that, okay, I consent to you collecting my data, but certain action by the individual actually shows that consent can be deemed. And because it is deemed from the circumstances, it will have to be obvious. So the purposes are usually limited to those that are objectively obvious and reasonably appropriate from the surrounding circumstances. Because if it is not obvious, if you have to really argue that, oh, the individual has given consent, then it is not really reasonable. So it has to be obvious from the situation. And maybe what I can help is we have these advisory guidelines that we issued as a guidance to the industry. And under this deemed consent by conduct, we have 3 examples. So maybe I just talk a bit about these 3 examples, and it will be easier to see how we interpret. Okay, so this is the first of the 3 examples. So processing of payment. So in this example, the customer actually went for a spa, and at the end, she hands over her credit card. She may not have said anything at all, but by the act of handing over her credit card, the cashier does not need to specifically ask for the customer's consent to collect, use, or disclose her credit card number, because it is quite obvious that handing over a credit card means go ahead and use it for the payment processing. So in this case, the deemed consent by conduct would apply. A second example, this is a health checkup situation. So the patient is at the clinic for a health checkup, and the clinic gives the patient information on the test that will be conducted. And in the details, it says that there will be in collection of blood pressure, height, and weight. So by going ahead with the test, the patient is deemed to have consented for these purposes. Because if after reading the details, the patient could have chosen not to proceed with the test. So by going ahead with it, it is reasonable to say that the patient is deemed to have consented. And finally, the last example is in the example of a booking of a taxi. The customer calls the taxi hotline and gives her name and contact number to book a taxi. So it is the customer is deemed to have consented to the taxi company calling back to tell her, or calling or texting her when her taxi arrives. So the taxi company doesn't have to specifically ask her, is it okay for us to call you back or text you because by the action of booking a cab through the hotline, the customer is deemed to have consented to that purpose. But and you see at the end, we highlighted what is not considered deemed consent. So for example, if the taxi operator also runs another limousine service and now wants to use the customer's information to market for direct marketing, this would not apply because it is not obvious. The customer would not have consented for her personal data for this kind of purpose. And that's the end of my sharing. Thank you.
That was extraordinarily helpful, having these cases that illustrate how the PDPC has interpreted deemed consent by conduct. I would say if we're comparing it to the GDPR framework, most of those uses could have gone under necessity to enter a contract. And then perhaps the reuse for the limousine service was quite easily falling under legitimate interests. So this is the type of analysis that usually is done when we're seeing this type of processing activities. Ashish, I'm very happy to give the floor to you and move the conversation forward.
Thank you, and some very interesting conversation. So I just want to quickly follow up, Francis, to what you just said. So building on this deemed consent by conduct, you also have something deemed consent by notification, if I'm right. So just wanted to understand how does that play out, and also to build on probably what Gabriel just said, to what extent then this contractual necessity can be built in under this voluntary provision of personal data, according to you. Is that something that is possible, and what would be your thoughts? So a couple of follow-ups here.
Right, let me talk about the deemed consent by notification first. So it is essentially opt-out consent. When we say deemed consent by notification, what we tell organizations is that you can notify your customers of a new purpose for using their personal data, and you give them a reasonable period to opt out. And before using this deemed consent by notification, they also have to conduct an assessment to make sure that there are no adverse effects on the individuals. And at the end of this reasonable period, if there is no opting out, then the customer is deemed to have consented. So it's a convenient way, but we have safeguard in place by having the requirement for an assessment beforehand. And as for deemed consent by contractual necessity, I think there is an overlap with deemed consent by conduct, especially, for example, in payment processing. So handing over a credit card is actually to complete the transaction, to complete the contract. So that could potentially fall under the contractual necessity. But I think contractual necessity is necessary for other situations where they may not be obvious conduct. So one example is online shopping, where I buy something and I choose a delivery option. In order to complete the transaction, the seller would have to disclose my personal data to a delivery courier. So it's easier to say that as part of the transaction, the delivery provider would have to collect the information from the seller, because it will be a little bit hard to say that by clicking on a mouse click, I have deemed consented to certain things. But contractual necessity goes back to the contract, where you can use to say, okay, because this is what the customer has contracted for, so whatever that is necessary to complete it is necessary the disclosure is necessary for the completion. Thank you.
That's very helpful, that explanation. And before I move on to Kazim, just also want to say that the mapping which you showed on consent between GDPR and PDPC, I think that's very useful. So that is a kind of practice which, let's say, we can take back to our government and they can put that out, how our framework maps to some of the other laws. I think that can just be very insightful. So thanks for that. And this is a question I have for both Kazim and Leandro, probably, and more from the legitimate interest perspective. Just from a regulatory lens, what kind of challenges would you think that our government and regulator might face when we are looking at alternate to consent in terms of their fair use? And are there interesting examples where there have been cases or learnings where the authorities have developed some kind of internal practices to determine whether this squarely falls within the set of purposes which are available, or how is this entire area evolving? I mean, how are the regulators going about it? Some thoughts on this would be very useful. Maybe if I could request Kazim first. Yeah.
Well, it's a question to which if we had the answer a few years ago, I guess the GDPR enforcement would have looked differently. I would answer this question in an ideal world. In an ideal world, if I was a data protection authority who has just seen the law being adopted in the parliament, I would sit down with my colleagues and I would reflect what kind of practices in the industry that seem to be based on legitimate interest are affecting the most my citizens, are the most problematic, are the most controversial, are the most suspicious. And from there, I would try to understand whether I like them or not, and whether the legitimate interest works or not. What we observe, and it's natural, it's always like this, always in the history of the world, the authorities are reactive. And not only they are active, they are also limited by the tools they have. If it's, and there is certain tradition, I think, at least in the EU, of data protection authorities being complaints driven, reacting to what they receive, which gets even more tricky when it comes to cross-border cases between EU authorities. So again, kind of a more proactive, own investigation approach would be much more, useful. And I think it's a fantastic opportunity in India to seize that, and not to repeat these mistakes. And it's not me being kind of critical to. I mean, I am critical in a way, but I think it's something that in EDPB we're really trying to improve in terms of identifying strategic cases. But if there's one lesson that I think we can learn from GDPR is, for the love of God, let's try to map things in advance and be as strategic as possible, because everything else in terms of mechanisms, structures is against us, So even if you do map that, it's going to be still a struggle. So at least let's try to identify that. I don't know if this answers your question or more. It's a philosophical sense, but I think it's a fantastic moment to have a new law adopted, and I think it gives opportunities that we will not have, in years to come.
I think it's quite insightful, and that kind of insight probably doesn't come unless you have been in that practitioner's role, and that is something I think, given the need for the redress board to be very focused. I think that kind of an approach and that I'm sure that approach can be applied in many other concepts. I think as an approach, that's a wonderful approach for us to think about. Leandro, do you want to comment on the same question, and then I'll come with a follow-up? Yeah.
Yeah, I think especially at the start that there will be a lot of confusion on what the proper interpretation of certain concepts will be. So I think it's very important to be clear about how the board or the government interprets a lot of these things, because your fiduciaries will constantly be looking out for all of these cues. I think you also need to establish mechanisms to allow data fiduciaries to demonstrate their compliance with various specific requirements and obligations, and for government or for the board to be able to provide the necessary guidance so that there will be no confusion between what the board expects and what the fiduciaries are supposed to do. Because as Kashik mentioned earlier, initially, I think a lot of it will be complaints driven, but it would be good if you don't even get to the point of having complaints, because the requirements, the obligations are clear, both from the perspective of the board and the perspective of the fiduciaries. So having all of those clear guidelines and mechanisms to be able to demonstrate compliance with those obligations will be very important. So I think at the start, that's really what would be good, because a lot of these questions will be up in the air at the initial stages.
That's a very fair point, and I think one of the things that the government is in fact looking at is that how can the guidances be provided, because a definite framework for that isn't explicitly spelled out in the law itself. But I think that can certainly be very useful. And I just have one more question, and which maybe all three of you can answer. And in a way, you mentioned that, Leandro, that complaints. But just in the context of consent, what has been the experience do people really complain? So do these complaints happen in the initial stages out of enthusiasm, or is that a thing which builds and grows, and then complaints keep, taking a scale of its own, and not to reflect on the poor quality of anything, but to say that there is a mechanism which is willing to accept complaint? Or are complaints not really the thing? Is it more about impact assessment studies and regulators having to go in and do their own, review and remedy the practices? So just in terms of the overall balance between complaints and enforcement as a tool of getting consent work really well from a compliance point of view, over the years, is there some kind of experience which all three of you can kind of share that could be a little bit relevant from when we think about our and maybe if I could request Francis, maybe you can come in first on this.
It's very important for the regulator to have continuous conversation with the industry, because complaints arise because of certain practices certain businesses are doing, and then disagreements arise. But if the regulator can be proactive in talking to the industry and finding out what is already happening on the ground, we can actually anticipate maybe there might be certain lapses or less than ideal practices that can be fixed before the complaints come. And second, actually, we might discover best practices that certain organizations already adopt. And so we can use those best practices and disseminate to everyone, so that everyone adhere to these kind of best practices. So I think continuous consultation, engaging the industry is very important. Yeah.
Thank you. Kazim, do you have a comment on this?
Yes, I would. Thank you. I think the following. Is there a consent fatigue? Yes. Is consent giving sometimes a false feeling of control? Yes. If it's not suitable to certain situations, or actually many situations, absolutely yes. But at the same time, it's, at least looking at the GDPR experience, it's the tool that makes people know that there is a GDPR. I think GDPR is one of the, I think the best known legislation in Europe. Like my grandma knows there is a GDPR, and like if someone does something to her, she will say like GDPR to this person, you know, and like is her, you know, is her understanding of consent probably not you know, nuanced enough? Yes, for sure, you know, but in terms of, I wouldn't underestimate the importance of, you know, individuals knowing that there is a law and it gives me some sort of power. It's then up to us, to authorities, to practitioners, to you know, to make it workable, you know, to and all that all the things that we discussed. But I wouldn't just, you know, neglect consent just because, you know, it's a bit like, you know, simplistic or primitive, you know. I think it's important that people know that there is law. I think it empowers them, and I think data protection is all about empowerment. So I would kind of, you know, finish with like that kind of note.
All right, Leandro, do you want to share any experience in terms of how much complaints play a role, or what is the kind of experience you have in terms of the nature of complaints?
Yeah, so what we did in the Philippines once the law was passed was we gave companies a period of time to really get their compliance in order. And we also took the time to engage with industry, as Francis was mentioning, and also educate the data subjects about all of their rights. And what we realized was the more data subjects became educated, the more they understood a lot of these things, then the more they complained. So I think there's that situation. But over time, you realize that a lot of the things they're complaining about sometimes aren't necessarily covered by the Data Privacy Act. It's just that there's also that misunderstanding. But it gives us feedback so that we know what to address now in terms of which particular points we need to focus on when we continue our education efforts. So I think it's a useful feedback, but with how we do things, we are not waiting for private individuals to file their complaints. We can do our investigations on our own proactively, whether in the form of a criminal investigation or compliance checks that will result in ordering companies to take corrective action. But getting feedback through complaints filed by private individuals is a good tool also to figure out where everyone is at, because they're bringing to our attention things that we may not know about, we may miss, just because of how like big the Philippines is.
Yeah, I think that's a very effective way of kind of looking at what is really happening in the market and then being agile about it. And just one last question from my side, if I can kind of take that. You know, there is a ground for research purpose, which is pretty much there across jurisdictions as an alternate to consent. And given your experience of seeing this probably you know, play out, is there some way to share that how is that evolved and what all does it mean? Is it something that we can understand better from your experiences? Again, something that will be very interesting if it's possible to share something on that. Maybe I can request Kazim, again, you to comment first.
Sorry, could you repeat? I'm not sure I fully understood the question.
So processing for research purposes, that being an alternate to consent, and just to understand what is the evolution of that and what all one can understand as being covered under that, that could be some bit of insight for us, because we also have a similar exemption.
Yes, no, it's a fantastic question, and indeed, I think something that in the context of GDPR and transfers topic became particularly problematic in past years, you know, specifically when it comes to medical research, for example. And I think there is kind of a reflection, especially in past, you know, year and months, maybe specifically on both sides, that, you know, now that we have, of course, data privacy framework with the US, it's a bit easier. But before that happened, I think there was a kind of common understanding that the rules on transfers and the and the whole system of data protection kind of probably maybe not fully recognize the importance of research and how much data plays a role here. I don't have any kind of tangible conclusions out of it, other than just to say it's good that it is being recognized as something kind of standalone, something worth maybe specific, maybe tailor-made approach. That doesn't mean I'm questioning GDPR approach to this or whatever, but I'm just saying yeah, indeed, caution and recognition is very much necessary in this field. I don't think data protection was ever designed to hamper the research per se, unless it's unethical or whatever. So yeah, just I think that the very fact that you're asking this question is a representation of kind of recognition of the importance of it. That's I think all I would say at the moment to that.
All right. If there is no further comment on it, I'll hand it back to Gabriel. But if there is, happy to take that answer too. Thanks.
I was just quickly checking if Francis or Leandro wanted to add something. I would add that indeed, even if the GDPR doesn't recognize a specific lawful ground or exemption for research, it's very, very important to note that reusing personal data for research purposes, archival purposes, it's actually allowed as one of the reuses under the purpose limitation principle. And in the EU law system, we still have to better understand what does this mean in practice. But I think it's important to note that there is this addition, let's say, to the purpose limitation principle, allowing the reuse of data for research purposes. And I know that under the DPDPA, the research exemption is laid out very specifically there, which I know will encourage, let's say, fiduciaries to use personal data for research. Then the question is, how far can you take it, and what does research mean? Because you have academic research, you have product improvement research, you do research for your own product improvement for commercial purposes. And I think this is a space where the future data protection regulator will, and the government, because I know that the government has primarily competence to provide guidance, will have to play a role to set some boundaries. I would just like to thank very much our distinguished panel. I hope this conversation was very helpful in the public policy debate right now in India and how it will be shaped. Just one thought to conclude on my side. We highlighted how important lawful grounds for processing are, because they're the foundation of data protection law. But then once we solve this, we need to remember that there are many, many other safeguards that happen to afterwards. So we ensure that we have a lawful ground for processing, and it's a lot of hard work. And once we ensure that we have a lawful ground for processing, then we need to look towards the rights of the data subject, towards accountability obligations, data protection impact assessments, and so forth. So that's the second part of the conversation, in a way. Thank you very much, Ashish and the nasscom team for bringing this conversation to India. And we're looking forward to a future collaboration.
Yeah, thank you, Gabriel, and thank you to all our panelists. It has been wonderful and very insightful. And just on that note, I would very much like to mention we have another set of panel discussion which will be coming up later this month. I think it's on the November 22nd, for which we'll be reaching out. And there I think we'll shift the focus a little bit, not just from the law, but also looking at some of the techno-legal measures in terms of consent manager and so on and so forth, so that a complete look at consent and some of this. So again, thank you, Gabriel, for this collaboration, and very much appreciate this. And thank you, and have a good day. Bye-bye.
Goodbye, everyone.